think this is a chance to talk a little bit more about what it feels like from a human angle, what it feels like to be on the receiving end of aggressive litigation. And we've heard from Richard with regard to that, and we know we've got some questions. I will promise I'd come to you, Adele. We can.
I think you're amazing.
Thank you, Adele.
Thank you.
But Lee,
Morning.
thank you very much for that, Adele. Yes, at that point. So Lee, I'm going to leave you to introduce yourself to everyone who's here and everyone who's here online.
Can I just say something on the last point
Of
that
course you can.
Richard eloquently answered? You are all, not all, but most of you are qualified people in law. You're all regulators. Every one of you can call anyone out. If somebody in your practice or co-worker or whomever is doing something that they shouldn't be doing, call them out, tell them, make sure they don't do it. You know, you're all able to do that. It shouldn't be that you need a regulator to tell you what is right and what isn't right. You're all human beings. Anyway.
Thank you for that, Lee. Lee, we really want to hear something of your experience, but you just alluded there to the fact that everyone's a regulator. Tell us about your experience. What were you doing before you were a sub post office?
So I joined the Air Force in 1987 as an electrical engineer. And when I left the Air Force after 9 years service, I spent a couple of years as a stockbroker.
And that's a regulator.
Absolutely. Not very good stockbroker, I might add. My wife and I were looking for a small business locally to where we were both born. And we found a post office and we thought that that was the right move for the family.
Did you have experience with the legal system prior to?
No, none whatsoever.
No? Okay.
No legal experience. No, I've never, apart from obviously this 20-year battle, I've never had, you know, any reason to be in a legal argument in any way, shape or form.
So let's take you back to then. So you're a post office master. Can you hear me all right? Sorry, thank you. Let's take you back. You were a sub post office master. You received those formal court documents. They came through the door in the post. How did you feel?
Wow, yeah. Just as a bit of background to that, the process to getting to there was that I'd been very open. We'd had losses in the office for 12 weeks. I'd raised it and got no help. I believed that the post office, being the post office, would swoop in and help me find out the reason why, what was going on and what had happened in the office. And actually quite the contrary happened. They just closed the doors and set on this road to court, really. They just wanted this money that they said I owed back. They started off in county court. And probably the worst thing of this whole 20-year journey that probably made the whole thing even more aggressive was the fact that they applied to county court to receive this £25,000 back, but they never turned up. And so the judge awarded my counterclaim, which gave them a line in the sand, something that they had to overturn, something that they had to crush, which subsequently led to a high court case, which by the time I got to there, I'd run out of money. I had a £50,000 legal insurance fund that I'd used by the constant back and forth between the two legal parties. And I ended up standing in front of a judge and being judged.
And that was standing in front of as a litigant in person, I think.
Absolutely, yeah. So I was a litigant in person way back in 2006, December 2006.
How were you treated as a litigant in person? How did the judge react to you? How were the opposing lawyers dealing with you?
Very politely, you know. It was just the underpinnings of the detail, you know, I felt so frustrated because I just didn't know. And it was that very fast learning curve. If ever anyone gets the chance, there are the tapes with the inquiry. You can actually listen to me cross-examining. Not that you'll learn anything. It was a huge learning curve for me and very isolating, very difficult to understand and comprehend the little terms and nuances and the details that the judge really needed to see or hear. As Richard absolutely quite rightly said, the burden of proof had been reversed because of the system being seen to work correctly, and therefore I needed then to prove either the system wasn't working correctly or the output of the system was incorrect. And that's a very difficult thing to do when you don't actually own the system, have any access to the system. Because from the day that I was suspended, I had no further access to that system. I couldn't just draw down paperwork or do anything. I was completely reliant on disclosure. And as we all know from the inquiry, that disclosure isn't really one of the post office's strong points. And it led to lots and lots of disasters personally, you know, trying to make an argument that was understandable for somebody in a legal world up here and me in a legal world way down there. It was just a very difficult bridge to cross.
Is there anything that you feel should have been done, could have been done to prevent the process from being so weighted against you? Recognising you were just talking about that power imbalance.
Well, obviously I'd run out of money. I do believe honestly that money, whether it should or shouldn't be, is a door to justice, and certainly in civil litigation, especially when you're at the receiving end of somebody who has limitless power. We're talking about a taxpayer-owned company, a company that can just deeply dip into pockets to make an absolute precedent of anything that it wishes, seemingly. And that disadvantage, that uneven floor is very, very, very difficult to overcome. It's very difficult, even if you have, and as we can see now from the evidence being provided to the inquiry, a complete and utter failure throughout the whole process. Even though those failures are happening live, real time, it's taken 20 years to draw them to light, and it's taken 20 years of really hard fighting by a fantastic group of people.
And Lee, I mean, recognising, I mean, this is such a topical and current issue. Thinking about what Stephen and Richard were talking about, access to justice and the rule of law. How do you feel about that now?
I think it just gets worse, really, as budgets are tightened. Self-regulation. I'm an electrical engineer and we self-regulate every day. I would never leave anything that could cause harm to anybody. On a personal level, I think it's really, really important to me that I go home every night and I'm able to sleep. I would question whether any of the lawyers involved in my case particularly should have slept.
Lee, my final point for you, because I do want to open things out to others. You've got a sense of who was in the room. So you're looking around earlier. What would be your message to colleagues based on your legal experiences? What message would you like people to leave today with?
I mean, I've been a litigant in person and I've been a member of a GLO, a group litigation order, and both experiences I would never want to repeat. I really wouldn't. It's been a very difficult journey. I feel as though we've always been as a group at the end of the list, at the end of the group, you know, even now in redress with the government going through the series of hoops that you have to jump through, and this problems and the lawisms, the legalisms of the whole process has been very difficult for just a person to navigate. And I just wish that more people would see the human element, just that person at the end of the line.
Thank you very much.
Thank you.